can be the owner of the goods. So who now owns the goods? The original owner or the third party? Nemo dat quod non habet says you cannot give what you haven't got. So the rogue who has no title cannot pass title to the third party. The Nemo dat rule is enshrined in section 21 sub 1. 21 sub 1 says, where goods are sold by a person who is not their owner and who does not sell them with the authority or consent of the owner, the buyer acquires no better title than the seller had unless. Now, the Nemo dat rule, of course, is unfair to third parties because the thing is, the original owner voluntarily gives possession of the goods to a rogue. So the owner chose to give possession of the goods to someone else without making sure he gets paid. So he's kind of at fault in a way. Whereas the innocent third party who buys goods from the rogue, the third party has no idea what happened beforehand. He has no idea that the rogue had no right to sell the goods, and in good faith, he pays money for the goods. So how do we deal with these competing interests? Devlin, in Ingram against Little, he said, where there are two innocent parties and one had to suffer the loss, there is no good basis for choosing between the two. He suggested a system to apportion the loss. This was a fairer way to resolve the problem when two innocent parties are involved. Now, the Law Reform Committee back in 1966, they considered Devlin's suggestion, but ultimately they rejected the notion of apportionment. They said it was impractical. You can't have two people owning and sharing possession of the same goods. You can't, for instance, say, the original owner has the goods Monday, Tuesday, and Wednesday, and the third party has the goods the other days. This is just not workable. In any event, goods often pass through several hands. The rogue sells to A, who sells to B, who sells to C. How do you apportion loss? All of these people are innocent apart from the rogue, and none of them know about the rogue until much later on. The Law Reform Committee didn't like the idea of giving judges freedom to apportion loss. They said it would produce too much uncertainty, which of course we know the business community does not like. So how does the law deal with the problem if apportionment is not workable? The current law essentially takes an all or nothing approach. Either the original owner remains the owner, or the innocent buyer from the rogue is now the owner. Both, of course, are innocent, but one of them is going to lose out. That's why Denning says it's a struggle between two competing principles. But not everyone agrees. Some say there is no struggle at all because the two principles are not equal. Goff, in the House of Lords case NEM against Jones, he said Nemo dat is the number one rule. Everything else is minor. Because it is not practical to apportion loss, the existing rules place the loss on one or the other, either the owner or the innocent third party. But the rules are not consistent, and some of them are difficult to justify. In fact, the exceptions are very narrow, actually. Unless the buyer can bring himself within quite technical rules, the innocent buyer loses out. The upshot is that the Nemo dat exceptions exist to help the innocent third party. But do they really protect the third party? I mean, Denning, as you know, in Bishopsgate, he says these two principles have striven for mastery. Goff in NEM disagrees. He says the fundamental principle is Nemo dat. This for sure has now been enshrined in section 21 sub 1. Goff says yes, there are exceptions, but the Nemo dat rule is the big one. That's the number one rule. Goff says the exceptions are minor. So there are two opposing views. So let's go through each Nemo dat exception and see whether that exception truly helps the third party. We've looked at the first exception, estoppel. Section 21 sub 1, of course, is the Nemo dat rule itself. Only the owner can pass good title. But 21 sub 1 goes on to say, unless the owner by his conduct is precluded from denying the seller's authority to sell. So the very first Nemo dat exception is contained in section 21 sub 1 itself. We looked at the cases. The estoppel exception can only help the innocent third party if the representation by the original owner that someone else has the right to sell was intentional. So just because the original owner gave possession of the goods to someone else, in itself, that is not sufficient to say that that someone else had the right to sell. There must be a clear representation from the original owner. It must be something more than just giving someone possession. Now, in mercantile credit against Hamblin, Mrs. Hamblin, remember, she wanted a loan and she was prepared to offer her car as security. The car dealer was a rogue. He asked her to sign a blank form. He filled in this form, making it look as though he was the owner of the car and that he was going to sell it to the finance company. The finance company accepted the forms, but who now owned the car, Mrs. Hamblin or the finance company? The court said, oh, Mrs. Hamblin was still the owner of the car because Mrs. Hamblin did not intentionally nor negligently represent that the car dealer had the right to sell. Now, what this case shows is that even if the original owner signs a form in blank, and this is what allowed the rogue to commit the fraud, this does not constitute intentional nor negligent representation. So, although this estoppel exception is supposed to protect the innocent third party, it's clear that the application of the exception is very limited. We also saw the case of Moorgate Mercantile Estate against Twitchings. Even though the original owner, the finance company, was careless, not registering the customer's hire purchase agreement with HPI, the court held this did not amount to negligent representation that the customer had the right to sell. So again, the estoppel exception did not help the innocent third party. Wilberforce, in Moorgate Mercantile itself, said English law takes a robust line. The owner of goods is not under a duty to safeguard it. So the point is, just because an owner is careless, the third party is not always protected by the estoppel exception. We also saw the case of Central Newbury against Unity Finance. The finance company gave possession of the car and the registration book to a rogue without doing any credit checks. The rogue sold it to a motor car dealer. Question for the court: who was the owner? The original finance company or the innocent motor car dealer? The motor car dealer argued the finance company, by their conduct, they were negligent because they had handed possession of the car and the logbook to the rogue without doing credit checks. So the finance company ought to have foreseen the possibility that the rogue would sell the car to an innocent third party. The Court of Appeal said the finance company was still the owner. Just because the finance company was careless, this did not mean estoppel can be raised to defeat his title. The majority in this case clearly followed Wilberforce's robust line. So the loss fell on the innocent third party rather than the original owner who gave possession of the car to the rogue. So you see, just giving possession of the goods to a rogue, that does not amount to representation that the rogue has authority to sell them, nor is it negligent to do so. The court gave an example, if you remember. They said, if a householder, they left a window open and goods are stolen as a result, the court said, sure, the householder has been careless, but it does not mean that the householder is not the owner of the stolen goods. There is no duty of care owed to ensure that goods don't get lost or stolen. So actually, you see, this estoppel exception is very limited. It doesn't really help the third party. That's where we got to on Tuesday. Now, the second Nemo DAD exception is the factors exception under section 21 sub 2. What is a factor? Well, a factor is a mercantile agent who is entrusted with goods of another person and has the right to sell those goods in his own name. The definition is in section 1 of the Factors Act. Examples of factors are auctioneers, motor car dealers, art dealers. Every time you see any of these people in an exam question, auctioneers, motor car dealers, art dealers, you know that it is the factors exception you need to discuss. Section 21 sub 2 of the Sale of Goods Act adopts section 2 of the Factors Act. Factor can pass good title to a third party. 4 conditions need to be satisfied. All 4 conditions, not just 1 or 2. All 4 conditions must be satisfied. The first condition is that goods are in the possession of the factor in his capacity as mercantile agent. In other words, in his buy and sell capacity. Example, if you leave your car with a garage for service only, the factors exception cannot apply because the factor has possession as a car service repairer, not as a mercantile agent in his buy and sell capacity. He only had possession as to service the car. That's all. So the factors exception cannot apply. Having said that, you see, sometimes it is difficult to tell if a person is a mercantile agent or someone with goods on a sale or return basis. Now, this is a problem for the buyer. It is important to know in what capacity the agent received the possession of goods. Usually, of course, the end result is the same. Because if the agent has the goods in his capacity as mercantile agent, then the innocent third party gets good title under this, the factors exception under section 21 sub 2. If the agent has the goods on a sale or return basis, the innocent third party gets good title because the person adopted the transaction under section 18 rule 4. We saw the case of Kirkham against Attenborough. So you can, once you adopt the transaction, that's when property passes. And if that's the case, that's also fine. Property can pass. Now, the distinction, however, can be very important because it is possible to contract out of section 18 rule 4, whereas it is not possible to contract out of the factors exception. How can we contract out of section 18 rule 4? Well, the answer is where the seller makes his intention clear. That's under section 17. Property only passes whenever the parties so intend. So if you didn't want property to pass, then of course you make your intention clear. If that's the case, Section 18, Rule 4 cannot apply. Of course, seller can always reserve title to goods until he's been paid anyway. We know that under Section 19. We're talking about the factors exception. What we're saying is 4 conditions need to be satisfied in order for the factors exception to apply. The first condition is that the factor must hold the goods in his capacity as mercantile agent, in his buy and sell capacity. Second condition, the mercantile agent has possession of the goods at the time of sale or disposition. Easiest, I think, if I just make up an example. Example, you want to sell your car. The mercantile agent has possession of your car and he shows some potential buyers around. No decision yet, but you take back possession of the car to drive around it. The potential buyer then agrees to buy from the mercantile agent. Well, that buyer is not protected under the factors exception because at the time of sale, the mercantile agent was not in actual possession. So the third party loses out. The third condition is that the factor must be in possession of the goods with the consent of the owner. 2 cases. Stadium Finance against Robbins. The car owner left his car with a dealer to see if the dealer could find a buyer. The owner kept the keys, but he accidentally left the registration book in the glove compartment. The glove compartment was locked. The dealer sold the car to a finance company. Who was the owner of the car? The court said the original car owner was the owner. The owner did not consent to the seller being in possession of the registration book. It was in a locked glove compartment. A sale without the registration document is not a sale in the ordinary course of business. This is, in fact, the 4th condition. It's interlinked. Note that consent is given even if obtained by deception. It is arguable, of course, that if the owner was deceived into giving consent, then that is no consent at all. It is arguable, I know. But the courts are trying to protect the innocent third party. But that protection cannot be taken too far, as you can see from the case of Pearson against Rose and Young. An owner left his car with a dealer with instructions not to sell, but to see what offers he could obtain for it. The dealer was a rogue. He intended to sell the car and run off with the money. The owner did not intend to leave the registration book, but the dealer arranged for the owner to be called on a fictitious emergency. So the owner forgot the registration book, left it in the car. The same day, the dealer sold the car to a bona fide third party. The court said that the goods was the physical car and the registration book. The dealer was in possession of the car with consent, but not in possession of the registration book with consent. A sale without a registration book is not a sale in the ordinary course of business, which is the next condition. The 4th condition is that the factor acts in the ordinary course of business. In other words, he must be selling in normal business hours, at a normal place of business, that sort of thing. Now remember, the buyer must act in good faith and have no notice of the seller's lack of title. And that burden of proof is on the buyer. The buyer has the burden of proving he acted in good faith and he had no notice. We saw before the case of Heap against Motorist Advisory. The mercantile agent was a rogue. He sold the owner's car to a buyer who were themselves car dealers. The car was sold for half the price, there was no registration document, and the mercantile agent asked for an open check because he said he didn't have a bank account. Well, the court said the buyer, in these circumstances, did have notice of the defect in title. The mercantile agent was not acting in the ordinary course of business. There are 8 Nemo DAD exceptions we need to look at. We've done 2 of them, the estoppel exception and the factors exception. The third one is second sale by seller left in possession. This is section 24. Section 24 says, if a person having sold goods remains in possession of the goods and he sells or otherwise disposes it and delivers it to a third party, the bona fide purchaser for value gets good title. This is the same as section 8 of the Factors Act. Example, I sell you a car. I agree to deliver it in 7 days' time, but I sell and deliver it to someone else, to a third party. Section 24 says this innocent third party, he gets good title. Note 2 things. First of all, it does not matter why the seller remains in possession of the goods. So if you buy a car from a car dealer and you ask him to respray at your cost, if that car dealer sells your car, this is a second sale by seller in possession. It doesn't matter why he had the car in his possession. Section 24 says third party will get good title. What is important is that the seller must remain in possession. So if you buy the car from a dealer and you take delivery, later you take it back the next day, you're asking for a respray, and then the dealer sells to third party does not get title under section 24 because the seller did not remain in continuous physical possession. Of course, it doesn't literally mean the car dealer has the car in his physical garage or in his pocket. The normal commercial meaning is applied. So the car is in the seller's possession if it is at his disposal. So it could be in his body workshop or the respray shop. The second thing to note is that the third party must take delivery of the goods before section 24 can help him. Example, I sell you a car. I agree to deliver it in 7 days' time. In fact, I sell it to someone else, the third party, but this third party has not yet collected the car from me. You are still the owner if you collect it before the third party. Let's look at the case of Worcester Works against Cooden Engineering. Now, it's a rather complicated case because it involves another Nemo DAD exception. So this case always sounds a bit confusing the first time you hear the facts. This case involved an owner who sold his car to a motor car dealer, and he gave the motor car dealer possession of the car in exchange for a check. The dealer sold it to the finance company because the car was going to be the subject of a hire purchase agreement with a customer. The check the dealer gave the owner bounced, so the original owner returned to the garage and repossessed that car, which the motor car dealer had not yet delivered to the customer. When the owner repossessed the car from the dealer, the finance company was already the owner. That's because the dealer was a buyer in possession under section 25, This is another Nemo dat exception, which we will discuss later. So leave that for the moment. The question for the court was, who was the owner? The Court of Appeal said the original owner was now the owner. This is the original owner. Sorry. This is the original owner. He was now the owner. That's because the motor car dealer, that's this guy here, the motor car dealer was a seller in possession. The first sale was the motor car dealer to the finance company. That's sale number 1. The second sale, the disposition, was the motor car dealer to the original owner. The motor car dealer had not yet delivered the car to the finance company nor the customer as is required by Section 24. So sale number 2 operated to transfer property to the original owner. Note that the delivery need not be actual delivery. Constructive delivery is sufficient. Constructive delivery means the right to possession. So if the motor car dealer had handed the keys to the buyer, buyer number 1, this might have amounted to delivery to buyer number 1. This means the seller did not remain in continuous physical possession of the car, and Section 24 cannot operate then to help pass title to buyer number 2. I know the facts of the case sound complicated, and they are, but that's because it combines 2 Nemo dat exceptions. I will come back to this case later on. Note sale and leaseback arrangements. In other words, I sell you my goods, I agree to lease it back from you for monthly installments. It's like paying rent. Lots of companies do this because of cash flow, and there are tax benefits. The case is Michael Gerson against Wilkinson. The seller sold goods to buyer number 1 on a sale and leaseback. So buyer number 1 is now the owner. The seller only has possession of the goods as bailee. It's like I'm renting the goods. The seller sold the same goods to buyer number 2, also under a sale and leaseback arrangement. Buyer number 1 is now suing buyer number 2 for conversion. Buyer number 1 argued there was no delivery to buyer number 2. So Section 24 does not help buyer number 2. Buyer number 2, the court said, had good title because delivery for Section 21 purposes can be constructive delivery. You see, sale and leaseback arrangements leaves the seller in possession throughout. It is deemed delivery to the buyer as owner, then re-delivered to the seller as bailee. So watch out for sale and leaseback arrangements. Because of this decision, you see, every time the seller sells under a sale and leaseback, the last buyer gets good title. If you see the diagram on screen now, seller sells to buyer number 1 and leases it back. The seller sells the same thing to buyer number 2 and leases us back. At the end of the day, the last buyer gets good title under this Nemo dat exception. Buyer number 4 ends up with title. Of course, yes, each buyer can sue the seller for conversion, and the seller is in breach of the leaseback arrangement. But the seller invariably has no money to pay, or he has absconded. So the action, you see, is always buyer number 1 against buyer number 2, etc. Okay, the 4th Nemo dat exception. Sorry, the question on the screen now is, what if the motor car dealer sells to another third party, not the original owner? Such another third party will get a good title, I suppose. Well, the answer is yes, because in Worcester Works, we call him the original owner because he really was the original owner. But you could just call him XYZ. It doesn't matter who he is. It's just a third party. All right. So as I say, Worcester works very complicated only because it involves two Nemo-DAD exceptions glued together. So when we come to look at the next Nemo-DAD exception, which is the fourth Nemo-DAD exception, sale by buyer in possession, I will talk about Worcester works again, because now we know about both Nemo-DAD exceptions. Then we can deal with the facts of that case again. All right. So sale by buyer in possession. Section 25, subsection 1 says, where the buyer obtains possession of the goods with the consent of the seller, a sale to a bona fide purchaser shall have the same effect as if the buyer were a mercantile agent in possession of the goods with the consent of the owner. The bona fide purchaser then gets good title. This is the same as Section 9 of the Factors Act. Now, there are two big problems with Section 25. The first problem is the phrase, as if the buyer were a mercantile agent. In other words, in order for the bona fide purchaser to benefit from this Nemo-DAD exception, the buyer in possession must have sold to him as if he were a mercantile agent. In other words, the buyer must be a notional mercantile agent. Now, these are very weird words, because if the buyer in possession is not a mercantile agent, how can he sell as a mercantile agent? Because if the buyer in possession is a real mercantile agent, then the factors exception would apply. Read literally, Section 25 only says as if. In other words, he doesn't actually need to sell as a real mercantile agent. It's just as if. It's a bit like Section 2, subsection 1 of the Misrep Act, which you would have studied in contract law. Section 2, sub 1 of the Misrep Act is the remedy for negligent misrep. If you remember, Section 2, sub 1 says, the misrepresentee is entitled to damages as if it was a fraudulent misrep. That means the misrepresentee gets full-blown tort of deceit damages. Because Section 2 sub 1 says damages as if it was fraudulent misrep, so everyone always thought Section 25 of the Sale of Goods Act merely operates to validate a sale as if the buyer in possession were a mercantile agent. Section 25 does not require him to act as if he were a mercantile agent. But the court in Newtons of Wembley against Williams said no. The court said the buyer, in other words, the rogue, must really behave as a mercantile agent. In other words, he must deal in the ordinary course of business as a mercantile agent. Now, what happened in Newtons of Wembley is this. The owner sold a car to a buyer, the rogue, for a dishonoured cheque. The rogue sold it to buyer number 2, who sold it to buyer number 3. The Court of Appeal said, in order for Section 25 to apply, the rogue, that's the buyer in possession, he must sell in the ordinary course of business of a mercantile agent. But it seems that the test of ordinary course of business is not at all demanding, because in Newton's, the case itself, the rogue sold the car in a London street market, in Warren Street. This, the court said, was enough to say that the rogue sold in the ordinary course of business of a mercantile agent. Sure, private sellers also sell stuff there, but dealers also sold stuff there. Court said that was good enough for the sale to be the ordinary course of business. So it's fairly lax. If a rogue was at home when he sold to buyer number 2, then Section 25 exception will not help buyer number 2. In this case, buyer number 2 got good title. London street market was sufficient. That was sufficient to act in the ordinary course of business. So in a way, you see, the effect of Section 25 is also very limited. Remember, the main principle is Nemo dat. You can't give what you haven't got. So this exception, Section 25, although it's supposed to help the innocent third party, it's very restricted. Let's go back to the case I mentioned earlier, Worcester Works against Cooden Engineering. We looked at this case under Section 24, second sale by seller in possession. This case involved both Section 24, second sale by seller, as well as Section 25, buyer in possession. That's why the facts of this case sound complex the first time you hear it. This is now the second time you're hearing the facts, so hopefully it will start to make sense. The owner here sold his car to a motor car dealer. He gave the dealer possession of the car in exchange for a check. The motor car dealer sold the car to the finance company. Now, the motor car dealer, when he sold the car to the finance company, he sold it as buyer in possession. So, under Section 25, the finance company was now the owner. That was sale number 1. Because having sold the car to finance company, the motor car dealer no longer had the right to sell. But because the motor car dealer remained in continuous physical possession of the car, when he gave the car back to the original owner, this was a disposition. And this amounted to sale number 2. The original owner is in fact the bona fide purchaser, and he got good title under Section 25. Now, I said there were 2 problems with Section 25, buyer in possession exception. We've just looked at the requirement that although the buyer in possession is not a mercantile agent, he must nevertheless act as a mercantile agent when he sells it to a bona fide purchaser in order for the bona fide purchaser to take the benefit of Section 25. The second problem is the words in Section 25. The words in Section 25 involve the consent of the seller as opposed to the consent of the owner. Now, seller and owner are not the same thing. Let's look at the House of Lords case of NEM against Jones. What happened here was a thief stole a car from the owner. The thief sold it to A, who sold it to B, who sold it to motor car dealer 1, who sold it to motor car dealer number 2, who then sold it to Mr. Jones. The owner claimed on his car insurance. Now, his insurers were National Employers Mutual, NEM. Once the insurance company paid out on the insurance claim, their rights are what we call subrogated to the owner's rights. In other words, the insurance company can stand in the shoes of the owner and try to get the car back. That's why NEM was now bringing the action against Mr. Jones, who was in possession of the car. Mr. Jones argued, hey, I'm entitled to rely on section 25 Nemo dat exception because Mr. Jones said he, motor car dealer number two, he was a buyer in possession with the consent of the seller. The seller is the person before him in the chain. The seller, in other words, is motor car dealer number one. So when motor car dealer number two sells, he sells with the consent of the owner. So when motor car dealer number two sold it to Mr. Jones got good title under section 25 exception. Well, this argument would be true if you take the literal meaning of section 25. But it can't be right. Lord Gough said, no, it's not right. Consent of the owner means the true, real owner, not any old seller in the chain. The true owner here never gave anyone consent to being in possession of his goods. A thief was involved. His car was stolen. So motor car dealer number two was not in possession with the consent of the true, real owner. Motor car number two had possession of the car with the consent of the seller, motor car dealer number one, but no one in the chain had the consent of the true owner. Seller and owner are not the same thing. So the insurance company won. Mr. Jones had to give the car back to NEM. You tell me, what would Mr. Jones do? What would Mr. Jones do? Mr. Jones lost, so Mr. Jones had to give the car back to the insurance company. If you were advising Mr. Jones, what would you advise Mr. Jones to do? He lost the case. You had to give the car back to the insurance company. So if you were advising Mr. Jones, what would you ask Mr. Jones to do? What would you advise him to do? You tell me. Absolutely he would. Thank you very much. He would certainly sue motor car dealer number two. For what? Well, for breach of either section 12 Sale of Goods Act or section 17 of the CRA. Because section 12 or 17 says the seller must have the right to sell, to do with title. So if you did not have title, you are in breach of a condition. So that's why you're right. Mr. Jones, you advise him to sue motor car dealer number two for breach of either 12 or 17, and he gets all his money back. What would you advise motor car dealer number two to do? Mr. Jones would sue motor car dealer number one and get all his money back. What would you advise motor car dealer number one to do? Correct. I agree. You would say, motor car dealer number two, you sue motor car dealer number one for breach of section 12 title. And motor car dealer number one, he would then sue B and get all his money back. B would then sue A to get all his money back. A, of course, loses out because invariably the thief cannot be found. Even if the thief could be found, he won't have any money anyway. Now, you can't sue the thief A and B. You can't sue the thief A and B together because of privity of contract. You can only sue one party, the party who sold you that particular car. Now, the point about this case is that if a thief is involved, no one gets title. Section 25 Nemo dat exception does not help anyone in the chain. The original owner is always the owner. Seller and owner are not the same thing. So the wording of section 25 sub 1 is incorrect. You see, what happened was the drafters of the Factors Act, which then became section 25 sub 1 of the Sale of Goods Act, made one small change to the wording. The Factors Act used the words as if the buyer were entrusted with possession by the vendor. Vendor meaning the seller. The words were then changed so that the Factors Act said as if the buyer were entrusted with possession by the owner. This should have been seller. See, the drafter clearly envisaged owner, vendor, seller as the same person. If you look at the very first line, the very diagram on the screen, this is what the drafter meant. If the owner, the vendor, the seller, the same person, if the owner, vendor, seller, if he sells to a buyer in possession and the buyer in possession sells it to a bona fide purchaser, the bona fide purchaser gets good title. This is fine. So yes, if the owner, vendor, seller is silly enough to give possession of the goods to a buyer, bona fide purchaser gets good title. But the big problem is if the owner and the vendor seller is not the same person, like a chain transaction, just like we saw in NEM against Jones. If you look at the second diagram, sure, the buyer in possession must obtain goods with the consent of the seller, the vendor. But what section 25 literally says is when the buyer in possession sells to a bona fide purchaser, it's as if the buyer in possession had the consent of the owner, the original owner. Look at the third diagram. So if the seller is a thief, the seller has no title to pass, but when the buyer in possession sells to a bona fide purchaser, the bona fide purchaser gets good title. The buyer in possession, this guy here, is deemed to have possession with the consent of the original true owner and not the seller. This cannot be right. The thief cannot pass title. He's a thief. But if the thief sells to a buyer in possession, the buyer in possession can pass title to other buyers. So somehow, although buyer number one has no title, but somehow buyer number two onwards gets title. That's why Goff in NEM against Jones said no. The fundamental principle is Nemo dat, enshrined in section 21 sub 1. Goff says, yeah, there are exceptions, but Nemo dat is rule number one. So when a thief is involved, forget it. No one after the thief gets title. The original owner remains the owner. Now, Lord Goff's quote, I've got it in your handout. Please read that in your own time. There is one exception to this rule. It was added as an amendment. Section 25 sub 2 says a buyer under a conditional sale agreement, which is a consumer credit agreement, is not a buyer in possession for section 25 sub 1 purposes. Now, consumer credit is in the syllabus, but I did say that I am not covering consumer credit. We won't examine it in the main summer exam sitting. 25 sub 2 says a buyer under a conditional sale agreement, which is a consumer credit agreement, is not a buyer in possession for section 25 sub 1 purposes. So what is a conditional sale agreement? Let me just make up an example. I agree to sell you a piano. You must pay me £1,000 each month for 12 months. At the end of the 12 months, the piano belongs to you. That is a conditional sale agreement. I sell you the piano, but the condition is that you will only own it once you've paid me in full. 25 sub 2 is saying that a buyer under a conditional sale agreement, which is a consumer credit agreement, is not a buyer in possession for section 25 sub 1 purposes. So if the conditional sale agreement falls within the Consumer Credit Act, section 25 exception cannot protect the buyer, because section 25 says the buyer is not a buyer for section 25 purposes. Now, if conditional sale agreement is not under the Consumer Credit Act, then yes, section 25 buyer in possession exception applies. I wouldn't worry about this exception too much. If we want you to include section 25 sub 2 in your answer, and this is in a problem question, then we will just tell you the conditional sale agreement does or does not fall within the Consumer Credit Act. If it is an essay question, then just mention the exception and be done with it. No need to discuss the Consumer Credit Act. Okay, we're looking at the Nemo Dat exceptions. We said there are 8 of them. The 5th Nemo Dat exception is market ouvert. This used to be section 22. It's now been abolished. I want to tell you about it anyway, and I will explain why in a minute. Section 22 said that a sale by a trader in a market ouvert passes good title to a third party, even if he did not have title. Now, market ouvert was any shop in the City of London or in an established open market. There are loads of towns and villages in England that have weekly markets selling all sorts of things. Now, when I say any shop in the City of London, it's a specific area in London. I'm not talking about Regent Street or Oxford Street. Now, market ouvert rule was criticised for years. It was only abolished by the 1995 Amendment Act. Having said that, it was going to be resurrected, okay, in a slightly different form. But that's because European Commission was keen to harmonise the laws of member states, and most member states have a type of market ouvert rule. But then, of course, we've now Brexited. So even if the market ouvert rule was brought back to life in England, there were going to be exceptions anyway. So, for instance, cultural goods or artworks, for example, which were wrongly removed from a member state or imported pieces of stolen art. They were going to be exceptions anyway. But the new UK government, of course, is very busy right now. There is no time for them to look at Nemo Dat exceptions and discussing whether we're going to be reviving the market ouvert rule. Well, certainly not before your exams anyway. Now, I think that's probably a good place to take our 10-minute break. When we come back, we'll start off with the 6th Nemo Dat exception. All right, so we'll take a 10-minute break now. Okay. Okay, hi. We've got a question here, which is asking which textbook could you use for consumer credit? Well, the book that you're going to be getting anyway in November, that's the Rob Stokes book. That will have a whole chapters, we have a whole section, part 3, I think it is, on consumer credit. So that textbook that you're given anyway will have consumer credit in it. Okay, let's look at the 6th Nemo Dat exception. This is section 23 of the Sale of Goods Act. A sale by a person with a voidable title. Section 23 says, where a person has voidable title to goods, and that title was not avoided by the time of sale to a third party, the third party gets good title. Section 23 is talking about voidable title. This is not the same as void title. So How does one avoid title? Well, clearly, if you find the rogue, fine. But the rogue always absconds. So how can title be avoided? The case is Carr and Universal Finance against Caldwell. The owner of a car sold it to a rogue for a check. Of course, the check bounced. The owner couldn't find the rogue, so what he did was he called the AA, the Automobile Association, and he called the police before the rogue sold the car to an innocent third party. Question for the court: who owned the car? The original owner or the third party? The court said the original owner owned the car because he had contacted the AA and the police. He did everything he could to avoid title. He did this before the rogue sold to third party. So the contract between the original owner and the rogue was avoided under Section 23. Note that this case has been severely criticised. The Law Reform Committee back in 1966 recommended the reversal of Caldwell. In other words, you must have actual communication to the rogue before title is avoided. But this recommendation was not adopted. Back to the case we saw already, Newtons of Wembley against Williams. The owner sold a car to buyer number one. Buyer number one was the rogue. Rogue then sold to buyer number two, who then sold to buyer number three. Before buyer number one, that's the rogue, before buyer number one sold to buyer number two in Warren Street Market, the owner also took steps to avoid title. The Court of Appeal said title was avoided under Section 23. But the Section 25 exception applied. Buyer number one, the rogue, was a buyer in possession of the car with the consent of the owner. So when he sold it to buyer number two got good title under the Section 25 exception. Of course, buyer number two gets good title only if the rogue sells in the course of business. We know the test of the ordinary course of business is not demanding, but the buyer of the rogue does nonetheless have to sell in the course of business in order for the innocent buyer to get title under Section 25. But it's very lax. Selling a used car in a London street market was sufficient to satisfy selling in the course of business. Remember what NEM against Jones said, Lord Gough said in NEM against Jones. The question here on the screen is comparing Section 6 and Section 7. What is the difference between voided and unvoided? Well, I think it's a bit late for us to discuss 6 and 7, all right? That was like kind of yesterday or the day before. But the difference between void and avoided, or void and voidable, enormous difference. I will deal with that in the context of Nemo DAP. Give me 5 minutes. Now, when we're talking about a thief, remember, we said when a thief is involved, no one gets title. Not under Section 23, not under Section 25. No. The original owner always remains the owner. Remember, someone has to lose out. You cannot have two people owning the same car. The rogue always absconds. So either the original owner is still the owner, that's Lord Denning's Principle 1, or the bona fide purchaser who paid good money and actually has possession of the car. That is Denning's Principle number 2. We need to strike a pragmatic balance. Section 23, that's the voidable title exception, is essentially saying if you let a buyer take possession of your goods before you get paid or before you make sure the check clears, then it is your fault, your problem. Same with Section 24, second sale by seller in possession. If you buy a car from a seller but you do not bother taking delivery of it, and the seller sells it to someone else, you lose out. The third party paid good money. It's your fault for not taking delivery of the car in the first place. Note, section 23 is the only Nemo doubt exception where the burden of proof is on the original owner. This is purely because of the wording of section 23. In other words, it is the original owner who has to prove that the third party was not acting in good faith. Now, back to your point about what the difference is between void and voidable, for instance. Well, we are talking about someone who has voidable title to goods. Section 23 does not apply to someone with a void title. Someone with a void title can never pass good title, because someone with a void title means there was no contract in the first place. Ownership never passed, so the Nemo dat is the rule. You cannot give what you haven't got. When does someone have void title? Answer: if there is an operative mistake. The contract is void ab initio. Ab initio means right from the start, right from initial, void ab initio. This essentially are the mistaken identity cases. This is where one party makes a mistake about the identity of the other party. There are two types of cases. Contracts inter absentes. Absentes means the parties never meet. So these are contracts which are made, for instance, by post. Contracts inter absentes. Between them, they are absent. The second type of case is contracts inter praesentes. Praesentes means they are present. The parties are meeting face to face. Let's look at both of these situations. Let's look firstly at contracts inter absentes. Absentes means this is where the parties never meet face to face. They are absent from each other. We need to reconcile two cases. Cundy against Lindsay. Blencarn was a rogue. He had an address at 37 Wood Street in Cheapside. He wrote to the seller offering to buy a large quantity of handkerchiefs. He signed the order so it appeared as though it was coming from Blenkiron & Co., which was the name of a reputable firm with premises on 123 Wood Street, Cheapside. The seller supplied the goods to Blencarn in the mistaken belief that they were dealing with Blenkiron & Co. Blencarn, the rogue, did not pay. He sold the goods immediately to third party for cash. Blencarn, the rogue, of course, absconds. So the seller brought an action against the third party for tortiously interfering with their goods. The seller argued the contract between the seller and the rogue was void because of mistaken identity. The House of Lords said the contract between the seller and Blencarn the rogue was void for mistake. Void means it's as if there was never a contract between the seller and Blencarn the rogue. So ownership did not pass to Blencarn the rogue, so ownership did not pass to the third party. So in this case, the third party was liable to pay damages to the original seller. Nemo dat quod non habet. Compare Cundy and Lindsay with Kings Norton against Edridge Merritt. The seller in this case received an order for wire from Hallam & Co. There was a note paper with pictures of a large factory, and there was a printed statement that they had branches in Belfast, in Lille and Ghent. In fact, Hallam and Co. did not exist. It was an alias for the rogue called Wallace. Wallace sold the wire to a third party for cash and absconded. The Court of Appeal said the contract between the seller and Wallace the rogue was not void for mistake, but it was voidable for fraud. In other words, ownership passed to Wallace until the seller set aside for fraud. So ownership passed to the third party before it was avoided. The third party was not liable in damages to the seller for tortiously interfering with someone else's goods, because they were now the third party's goods anyway. Now, what is the difference between these two cases? Well, the difference is that in Cundy, there were two entities involved. There was someone called Blencarn, the rogue, and there was another entity called Blenkirin and Co., the reputable firm. There were two entities. In King's Norton, there was one entity only, because Wallace was an alias for Hallam and Co. There was no mistake as to identity, because there was no one else. Hallam and Co. never existed. Only if two entities are involved can it be argued that the seller intended to deal exclusively with this person and not the rogue. Remember, the rogue invariably absconds and someone must lose out. Both parties are innocent, sure, but the law can only recognize one owner to property. Which party is more innocent than the other? If identity really mattered, I only wanted to deal with Blenkirin and Co. I only want to deal with them. Then the courts will say, contract is void. If identity did not really matter, Wallace or Hallam and Co., whatever you want to call yourself, if it didn't really matter, then the contract is not void. There's one more case on this, Shogun Finance against Hudson. The rogue here produced a stolen driving license in the name of Mr. Patel. The finance company agreed to let the rogue take the car away for a 10% deposit. The rogue sold the car to Mr. Hudson. The question for the court was, who was the owner of the car? Was it the finance company or was it Mr. Hudson? The House of Lords said that the finance company was the owner of the car. The contract between the finance company and the rogue was void for unilateral mistake. The finance company wanted to deal with Mr. Patel only. There were two entities involved, the rogue and Mr. Patel. So the court essentially confirmed Cundy against Lindsay. Now, it is important to note that this decision was a 3-2 of the House of Lords. The dissenting judgments are very important in this case. Let's discuss that after we look at contracts inter price centers. Inter price centers, this is where parties deal face to face. They are both present. Now, obviously, it is more difficult here to claim I did not mean to contract with the person in front of me. 3 cases need to be reconciled. Phillips against Brooks. Phillips was a jeweler. The rogue entered his jewelry shop. The rogue chose a pearl necklace, £2,550, and he chose a ring, £450. He took out his checkbook and he was writing out a check for £3,000. As he was signing it, he said, "You see who I am. I am Sir George Bullock." And he gave a London address, which the jeweller checked in the telephone directory. The jeweller reluctantly accepted the check. The rogue immediately went to the pawnbrokers and they pawned the ring for £350. Of course, the rogue's check bounced and the jeweller wanted to get the ring back from the pawnbroker. So who was the owner of the ring? The original jeweller or the pawnbroker? The court said the contract between the jeweller and the rogue was not void for mistake, but it was voidable for fraud. In other words, it was a valid contract because the jeweller intended to deal with the person in front of him. So the rogue got good title unless the jeweller avoided the contract for fraud before the ring was sold to the pawnbroker. On the facts of the case, the rogue already sold to the pawnbroker before the jeweller even knew the check bounced. So the pawnbroker got good title. But the next case temporarily upset this accepted principle. Ingram against Little. 3 old ladies, they advertised a car for sale. And a chap came along and he agreed to buy it for £717. He offered a cheque, but one of the sisters refused. The chap said, "But I am PGM Hutchinson. I have extensive business interests in Guildford and I live in Stansted House in Caterham." Caterham is a very posh part of England. One of the sisters went down to the post office to check the name and address in the telephone directory. The sisters finally agreed to accept the cheque. The chap drove the car away and sold it to an innocent third party. As you'd expect, the cheque bounced. The sisters brought an action to recover the car. The court said the contract between the sisters and the rogue was void for mistake. They only intended to sell to PGM Hutchinson. No title passed to the rogue, so no title could pass to the third party. Now, Devlin was the dissenting judge in this case. Ingram against Little. He was the one who said, where there are 2 innocent parties and one had to suffer the loss, there is no good basis for choosing between the 2. He suggested that the loss should be apportioned. Now, we know that the Law Reform Committee rejected Devlin's suggestion on that basis because it was just impractical. Because if A sells to B, B sells to C, C sells to D, then it's a chain transaction, isn't it? It's not practical to apportion loss. Now, the decision in Ingram against Little has been severely criticised, but it still stands. Much preferred is Lewis against Avery. The seller advertised a car for sale in a newspaper. The rogue offered to pay for it by cheque. He said, "I am Richard Green, the famous film actor." The cheque actually had the name R.A. Green printed on it. The seller was very reluctant, but the rogue then produced a special admission card to Pinewood Studios with an official stamp on it, and he had his name and a photograph there. The seller accepted the cheque. Of course, the rogue sells the car to an innocent third party and the cheque bounces. Denning in the Court of Appeal said that the contract between the seller and the rogue was not void for mistake, but it was voidable for fraud. Because title had not yet been avoided, the third party was not liable to the seller for wrongfully interfering with the goods because the third party was now the owner. The principle seems clear. Where parties deal face to face, but one is a rogue, the bona fide purchaser gets good title. The contract between the original owner and the rogue is not void for mistake, but it is voidable for fraud. That's because someone must lose out. We can't have two people owning the same goods. The question on screen here is, can it be said that in Phillips against Brooks, identity was not a factor leading to a sale? Thus, it was voidable for fraud, not void for mistake. Well, identity was a factor. It always is. Because when somebody tells you that I am ABC, then you think you are dealing with ABC. So as far as they're concerned, it was a factor. But clearly, when you are face to face somebody, you have a choice. Does it make any difference why I think you are ABC, or why when you write to me and you tell me you're ABC, why is it different? At the moment, we shouldn't have the situation. Well, put it this way. Of course it's relevant. But if I tell you I am ABC and you believe me, that's more your problem than the wholly innocent person who buys from the road. All right? So there's a slight difference there. Let me come back to that point later on. Of course, identity is important. But how important? We're here to try and protect the third party. Because remember, if you're the owner of the goods, you are the one, you have the choice. Do I sell to the person in front of me or not? If you do want to sell to the person in front of you, you take a check. Checks can bounce. So the innocent person who buys from the rogue, the innocent person pays cash. The rogue never wants a check. The rogue always wants cash. So the innocent party has given cash. He has no idea that you had given the car to someone else without checking you got paid first. All right? How do you judge between mistake and misread? And why should the latter make the contract void? Well, the latter does not make the contract void. The latter, the misread, renders the contract voidable. Misrep is something you studied in contract law. You know that if you can show that there is an actionable misrep, the contract is voidable at the option of the misrepresentee. Void only comes in if it is an operative mistake. Operative mistake. So it's a valid mistake. That's when the contract is void. Voidable is misrep, but you did misrep in contract law and you passed your exams. All right. Can I compare Phillips against Ingram and Little? The answer is no, because that's what we're saying. Ingram and Little is wrong. It's out on a limb. It's been seriously criticized. There's almost no distinguishing between Ingram and Little and all the other cases. But what I'm saying is Ingram and Little is unlikely to be followed. Lewis and Avery will be followed. Lewis and Avery will be followed. All right. Now, but when this point comes up in the exam, all right, when we're talking about mistaken identity, they come up in a group of 3 cases. All right. So you start up with Phillips, you talk about Ingram and say how it's been criticized, unlikely to be followed. We prefer Lewis. All right. Group of 3. In the same way with contracts inter absentes, it comes up in a group of 3, right? So it doesn't matter if it's absentes, praesentes, comes up in the exam, bang, group of 3 cases for each, okay? All right, so what we're saying here is unless the seller avoids for fraud before the rogue sells to a third party gets good title under inter praesentes. But how can a seller avoid for fraud? Well, obviously, if the seller can find the rogue, you tell him to his face, I avoid. But this is never possible. The rogue always absconds. Now, actually, we've seen the cases already. Carr and Universal Finance against Caldwell. The court said, by calling the AA and you call the police, the owner had avoided title. but this case has been severely criticised. In Newton's of Wembley against Williams, the court said, even if the owner managed to avoid title under Section 23 by calling the AAM police, Section 25, buyer in possession, would operate anyway, so that the innocent third party might still get title. Just to remind you, when a thief is involved, the owner never consented to anyone being in possession. NEM against Jones. The owner never gave anyone permission to have possession or title of his goods. The owner is totally innocent. That's why he will always remain the owner. So with contracts inter price centers, the contract itself is valid, and Ingram and Little is not good law. As I say, it stands as a decision because it's never been overruled, but it has been disapproved by all subsequent cases, including the House of Lords in Shogun Finance against Hudson. But it is possible to avoid the contract. The case is Hardman against Booth. The seller here went to Thomas Gandel and Sons' office. The seller negotiated with Edward Gandel. He thought he was dealing with the firm, but Edward Gandel was a rogue. He was dealing on his own account. The seller delivered goods to Edward, who sold them to a bona fide purchaser for value. The contract between the seller and Edward was void for mistake, because the seller did not intend to deal with Edward. He intended to deal with the firm Thomas Gandel and Sons. You see, in this case, it was the seller who went to the offices. He approached the offices of Thomas Gandel and Sons. This shows that the seller thought the identity of the buyer as very, very important. The seller only wanted to deal with the firm. So this case can be distinguished from Lewis against Avery. Let's go back to the inter absentis case of Shogun Finance against Hudson. The House of Lords said that the contract between the finance company and the rogue was void for unilateral mistake. The finance company meant to deal with Mr. Patel only, the court said. It was an inter absentis case because there were two entities involved, just like Cundy against Lindsay. Now, the House of Lords in Shogun Finance disapproved of Ingram against Little, but we know Ingram and Little has always been criticized anyway. What is important to note about Shogun Finance against Hudson is that it was a decision of 3-2 of the House of Lords. The dissenting judgments are very important in this case. The dissenting judges said there should not be a distinction between inter absentis and inter praesentis. The outcome should always be the same. In other words, the dissenting judges said they would overrule Cundy against Lindsay. It should not make any difference. The contract between the seller and the rogue should always be an okay contract. It's a valid contract, but voidable for fraud. The dissenting judges said that Lewis and Avery should be applied in all cases. Now, the dissenting judges, what they said was true, because it's very difficult to justify the inter absentis rule. Why should it make a difference? You see, at the moment, if I sell you face to face, the contract is okay, but it's voidable for fraud. Whereas, if I sell you something in writing and I think you're someone else, I get let out of the contract. Oh, it's void for mistake. Why should it make a difference? Because I'm the one, I'm the seller. I've been silly either way. I am taking the risk that your check might bounce. Why should it make a difference whether this is a price sentence or it's ab sentence? Why should it make a difference? Unfortunately, the House of Lords did not take the opportunity to change the law. The law still separates into ab sentence and into price sentence. But what about a contract made via a phone call? So if I call the motor car dealer and say, oh, hi, I'm Mr. Patel. Is this ab sentence or is it price sentence? Phone call. Well, Lord Walker, he was one of the majority judges. He suggested that a contract made via the phone would be price sentence. Now, if a phone is going to be price sentence, I suspect Zoom and FaceTime would be price sentence. But what Walker said, if you make a contract via the phone, that's price sentence. It's like being face to face. But everything else, like post and by email, that would be ab sentence. Well, that sounds okay. But it's still going to cause difficulties, isn't it? What about face-to-face negotiations, or we're on FaceTime or we're Zooming or maybe on the phone? So we have face-to-face negotiations, but then we end up with a written agreement. Is this price sentence or ab sentence? We don't know. What we know for sure is that someone has to lose out because the rogue cannot be found. So either me as the seller should lose out or you, the innocent third party, should lose out. If we say we abolish ab sentence and we follow Lewis against Avery, the seller tends to lose out. Maybe this is fairer. After all, I've been sillier. I chose to sell my goods to a person I don't know, and he turns out to be a rogue. I didn't want to make sure the check clears, whereas you are the wholly innocent bona fide purchaser. Okay, we're looking at the Nemo DAD exceptions. The seventh exception is stolen goods. Where goods are stolen and the thief is convicted of the offence, the court may order the person in possession of the goods, in other words, the third party to whom the thief sells the goods, to give them back to the original owner. Now, in the olden days, the stolen goods always had to be returned to the original owner if the thief was convicted. It's just section 148 just says that the court now has a discretion to decide who loses out, the original owner or the third party. If the court decides that the third party can keep the goods, then this is an exception to the Nemo DAD, because the third party then wins. But please don't bother to learn section 148 powers of the criminal court. Don't bother to learn that. All you need to know is that there is a stolen goods exception. I'd rather you spend your brain power on more important section numbers, okay? All right, there is one more Nemo DAD exception we need to look at, the HP exception. But let's see if you can work this out. Let me tell you the facts of Fadala against Polak. Now, Fadala is also an ROT, retention of title case. So we'll be coming back to this case anyway. Let me tell you about this case in the context of Nemo DAD. What happened here is that the seller sold second-hand generators to buyer number one. Buyer number one paid in full. Buyer number one had no storage facilities, so the seller agreed to store these generators on behalf of the buyer until the buyer found a sub-buyer. Buyer number one physically watched the generators being disconnected and transported to the seller's warehouse for storage. Shortly afterwards, buyer number 2 wanted to buy the generators. Seller sold buyer number 1's generators to buyer number 2. Buyer number 2 had no idea the seller didn't own these generators. Buyer number 2 paid in full. The seller then asked buyer number 1 if they could buy back the generators. Buyer number 1 agreed, but with an ROT clause. In other words, section 19. Buyer number 1 essentially reserved title in the generators until the seller paid them in full. What happened? The seller went bust without paying buyer number 1. Buyer number 2 was now suing buyer number 1. Now, both buyer 1 and buyer 2 are innocent, but one of them was going to suffer a huge loss. The court here held that the ROT clause was effective. In other words, title remained with buyer number 1. Section 21 sub 1 says the seller can't give what he doesn't have. Buyer number 2 is now arguing the Nemo Dat exceptions. So the question is, if you were advising buyer number 2, which Nemo Dat exceptions could buyer number 2 try and argue? Which Nemo Dat exceptions might buyer number 2 try and argue? Approach this very methodically. I would list the Nemo Dat exceptions and then I would go through each one. Of course, you only discuss the ones that are relevant. Now, I know we're only just doing the Nemo Dat exceptions now. In fact, we still have one more Nemo Dat exception to go through. So you won't have had a chance to write this up yet. You haven't even had your textbook, and you won't certainly have memorized anything yet. But you have to find your own way of remembering the 8 exceptions. I've made a sentence. Now, this is the list of the 8 Nemo Dat exceptions in the order we are discussing them. What I did was I took the first letter from each. E, estoppel. F, factors. S, second sale. B, buying possession. What I did was I took the first letter from each, then I made up my sentence. My sentence is this: every family should buy my very small house. Every family should buy my very small house. You see, that's why, I need to include market ouvert, even though it is abolished, because if I didn't include it, my sentence would be even sillier. It would be, every family should buy very small house. That's why I needed to put the M in there. So at least it reads, every family should buy my very small house. Now, you might laugh at my sentence, but you know what? My sentence is not as silly as it sounds. The section numbers follow nicely, actually. Estoppel. What's the section number for estoppel? Do you know? And I know we're only just doing it, so maybe you don't know yet. What's the section number for estoppel? It is section 21, 1. What's the section number for factors? Well, that is section 21, 2. Sorry, I can't write with this pen. It doesn't work very well. It's 21, 2. Second sale is section 24. Oops, dear me. I can't write it, but anyway, second sale is section 24. Buyer and possession is section 25. Now, these are the two that often, very easy, you can get muddled up. Second sale, is that 24 or 25? And buy and possession, is that section 24, 25? Well, as far as I'm concerned, you see, 24 comes before 25. And in my sentence, every family should buy second sale, buy and possession, 24, 25. That's why I can always remember which one is which. Second sale is section 24. Buy and possession, section 25. 24 comes before 25 in my sentence. Sure, it doesn't work perfectly because the other important exception is voidable title. Voidable title is section 23, but you know, I think I can live with that. Anyway, you work out your own sentence. Of course, you're welcome to borrow mine. It works for me. Every family should buy my very small house. Now, I know you're allowed to have the statute book with you in the exams, but you know what? You just don't have the time to go to the statute book and find out whether it's section 23 or 24 or 25. All I'm saying is this sentence is not as silly as it sounds, because at least I know estoppel is 21.1, then the next one's 21.2, and then of course the difficult one to know is whether second sale and buy and possession, which is which. I'm saying in the sentence 24 comes before 25. Anyway, back to exam technique. With Nemo-DAT exceptions, Nemo-DAT questions, what I do is I list out the exceptions, and then I go through a process of elimination. I delete the ones which are totally irrelevant because I only want to discuss the ones which are relevant, because you're not going to get marks for discussing stuff which is totally irrelevant. So I've written down my sentence, all these exceptions. Now, which ones are irrelevant? I'm going to delete the ones which are not relevant. Let me remind you, first of all, the facts of Vidala against Polak, and then you tell me. The seller sold generators to buyer number one. Buyer number one paid in full. Seller agreed to store the generators until the buyer found a sub-buyer. Buyer number one physically watched the generators being disconnected and transported to the seller's warehouse for storage. Shortly afterwards, buyer number two comes along and wants to buy those generators. But buyer number two didn't know the generators belonged to buyer number one. They thought the seller owned those generators. The seller sold buyer number one's generators to buyer number two. Buyer number two paid in full. Seller then asked buyer number one if they could buy back the generators. Buyer number one agreed, but with an ROT clause. In other words, buyer number one reserved title in the goods until the seller paid them in full. The seller went bust without paying buyer number one. Buyer number two was now suing buyer number one. Both buyer one and buyer two are innocent, but remember, one has to lose out. The court said the ROT clause between buyer one and the seller was effective. In other words, the title, property in the goods, remained with buyer number one. And as you know, the general rule in section 21 sub 1 is seller cannot give what he does not have. Buyer number two argued the Nemo-DAT exceptions. Buyer number two, remember, is the innocent third party. So if you were advising buyer number two, what I'm saying is which Nemo-DAT exceptions might buyer number two try and argue. Go through the list of exceptions and work out which is irrelevant. Just delete the obvious ones. Well, is it the HP Act? Well, definitely not the HP Act. So I'm going to cross that off. Not the HP Act. Stolen goods. Anything to do with stolen goods? Definitely not. So it's definitely not stolen goods. What about market ouvert? It's definitely not market ouvert because that's already been abolished anyway. It's there for the purposes of my sentence. What about voidable title? Now, if you're not sure, you've deleted the ones which are totally irrelevant, then you can start from the beginning. So, do we need to discuss these other ones? Because you can't be sure, because we've deleted 3 which obviously don't apply. Is section 21 sub 1 estoppel relevant? Well, not really. It's worth discussing to get your marks, but it's not really relevant, I think, in this Fedala against Polak, because you see, buyer number 1 did nothing intentional to represent that the seller had the right to sell. Remember, possession in itself is not enough. It's just like me lending you my car. That is not sufficient to represent that you have the right to sell my car. Possession by itself is not enough. So there was nothing that buyer number 1 did by their conduct to make it look as though the seller had the right to sell. There was nothing intentional. Mere possession, not sufficient for the estoppel exception to apply. What about section 21 sub 2, the factors exception? Is that relevant? Well, not really. Worth discussing maybe, but not really. Because, you see, in order for the factors exception to apply, the seller must act as a mercantile agent. The seller here was not acting as a mercantile agent because the seller was not in possession of the goods in his buy and sell capacity. The seller was merely storing the goods on behalf of the buyer number 1. He was not there to buy and sell. He was merely there as a storage facilitator. What about section 24, second sale by seller in possession? Is that relevant? Well, it's definitely worth a mention, but it's not going to help the third party. Why? Because the seller did not remain in continuous physical possession of the generators. On the facts of the case, buyer number 1 attended and watched the generators being dismantled, put on a lorry for transfer to the warehouse. The court said buyer number 1 took possession at that time. So the fact that the seller was storing the goods for him did not matter. That was a different arrangement. So the seller did not remain in continuous physical possession. That's why section 24 did not help buyer number 2. Hey, what about section 25, buyer in possession? Might that help buyer number 2? No. Section 25 does not apply because the seller was not a buyer in possession at the time he sold the generators to buyer number 2. Seller already sold to buyer number 2 wrongfully, and the seller only agreed to buy back the generators from buyer number 1 after he sold to buyer number 2. So the seller was not a buyer in possession at the time he sold the generators to buyer number 2. So section 25 cannot help buyer number 2. What about section 23, voidable title? Is that relevant? No. It's not a matter of a rogue who gives a check that bounces. The seller doesn't have voidable title. The seller has no title at all. At the end of the day, buyer number 2 lost. None of the Nemo exceptions applied to help buyer number 2. So in this case, Fedala against Polak, buyer number 1 was still the owner. So the Nemo exceptions worth discussing on the facts of Fedala were the first 4. Yes, worth discussing, but ultimately none of the exceptions helped by number 2 in this case. With problem questions, it is unlikely you will only discuss one exception. It's usually at least 3 or 4. So this looks about right. We're looking at the Nemo-DAL exceptions. We said we need to discuss 8 of them. The 8th one, the last Nemo-DAL exception, is disposition of motor vehicles under the HP Act 1964. Now, the HP Act, the Hire Purchase Act, applies to both hire purchase and conditional sale agreements. Now, hire purchase is very similar to conditional sale contracts, but the legal distinction is important. The Sale of Goods Act applies to conditional sale. The Sale of Goods Act does not apply to hire purchase. We know Section 2 of the Sale of Goods Act. A sale of goods contract is a contract whereby the seller transfers or agrees to transfer property in goods to the buyer. So in a conditional sale contract, the seller agrees to transfer property. When the buyer pays all the installments, the buyer then ends up with title in the goods. That's why the Sale of Goods Act applies to conditional sales. Authority, Lee against Butler. No need for facts. So I sell you a piano. The agreement is you pay me £1,000 per month for 12 months. At the end of 12 months, you own the piano. This is a conditional sale contract. It's a sale on conditional you pay me the 12 installments. Just to remind you, there is the Nemo-DAL exception in Section 25, buyer in possession. Section 25 sub 2 says, if the agreement is a conditional sale agreement under the Consumer Credit Act, the buyer is not protected by the Sale of Goods Act. So it is this exception, the HP Act exception, that might apply. As I say, the HP exception applies to both hire purchase and conditional sale agreements. Under a hire purchase agreement, you see the hirer is not someone who has bought or agreed to buy. Goods are merely bailed to the hirer with an option to purchase. So the Sale of Goods Act cannot apply because there is no sale, not until the option to purchase is exercised. The authority for that is Helby against Matthews. No need for facts. The relevant time is when the contract is made. Now, the HP Act Part 3 was designed to protect the innocent private purchaser. In fact, the whole of the Hire Purchase Act has been repealed except this Part 3. Note 3 things. The first big thing is that the HP exception only applies to motor vehicles. So we're talking about cars or vans or tractors. It doesn't apply to any other type of goods, only to motor vehicles. Secondly, the HP exception only applies where the seller is someone under a hire purchase on conditional sale agreement. Thirdly, the HP exception does not help the motor car trader or a finance company, not even if the trader bought the car for his own use. So if the buyer is a private purchaser, PP, he will acquire good title in 3 circumstances. I've got it up on screen. Under Section 27 sub 2, if the owner of the motor vehicle lets the hirer have it on HP or conditional sale, and the hirer wrongfully sells it to a private purchaser, PP, Section 27 sub 2 says the private purchaser will get good title. Although the hirer does not have the right to sell, nemo dat quod non habet. You cannot give what you haven't got. Title will pass to the private purchaser. It's an exception to the nemo dat rule. Under section 27 sub 3, if the owner of the motor vehicle lets the hirer have it on hire purchase or conditional sale, and the hirer wrongfully sells it to a trade or finance person, and that trade or finance person sells it to our private purchaser, section 27 sub 3 says the private purchaser will get good title. Section 27 sub 4 says exactly the same thing, except the trade or finance person doesn't sell it to private purchaser. He lets PP have it on conditional sale or a hire purchase. Note that with section 27.3 and 27.4, I've written down PP1. With 27.3 and 4, you need to ensure that the first PP from the trade or finance person is acting in good faith and without notice of the seller's lack of title. If this first PP is malifides, then someone, in other words, someone is not acting in good faith, then PP1 definitely does not get the benefit of this nemo dat exception, nor does anyone else after him in the chain. This is different to 27.2. Under 27.2, even if the first PP, private purchaser, is not acting in good faith, but let's say he sells it to PP2, and PP2 does act in good faith, this means PP1 does not get good title, but PP2 does. Section 27 operates in this way. The owner's title is deemed to have vested in the bailee, in other words, the trade or finance person, immediately before the disposition to the private purchaser. Essentially, there are three conditions which need to be satisfied in order for the nemo dat exception to kick in. Maybe that's a good place for us to take a 10-minute break. We'll come back and look at those three conditions. All right, 10-minute break. Right. Okay, we're looking at the HP exception. Now, essentially, there are three conditions which need to be satisfied in order for the nemo dat exceptions to kick in. First of all, it only benefits a private purchaser. Section 29 defines PP in negative terms. In other words, a PP is someone who is not carrying on the business of trade or financing of cars. So the trade or finance company in the chain is not protected. A trade or finance person is never excused from criminal or civil liability. Section 27 sub 6 says that. Now, a car dealer has no protection even if he is buying the car for his own private use. The case authority is Stevenson against Beverly Bentinck. No need for facts of the case, but essentially a part-time dealer was not a private purchaser. Note, of course, a company can be a private purchaser as long as the company is not in the motor trade or involved with the financing of vehicles. There are three conditions which need to be satisfied in order for the HP nemo dat exception to kick in. We said it only benefits the private purchaser. The second condition is that the private purchaser must act in good faith and without notice of the wrongful HP sale. There is no definition of good faith in the 1964 Act. So we turn to the Sale of Goods Act for help. We interpret good faith in the same way as Section 61 of the Sale of Goods Act. In other words, when a person acts honestly, whether or not negligently, good faith is a subjective test. In other words, was this private purchaser acting in good faith? The Court of Appeal confirmed this in Dodds against Yorkshire Bank. No need for facts, but essentially the court said this is a subjective test. Now, English law, of course, usually takes a subjective approach to good faith. But if the circumstances are seriously suspicious, I mean, for instance, the buyer is buying goods at 4 o'clock in the morning from the back of a lorry, the court may infer bad faith. As Lord Denning said, if you deliberately turn a blind eye, the court may infer bad faith. He said that in Worcester Works against Cooden Engineering. Now, the private purchaser must act in good faith and without notice. What does without notice mean? Well, under Section 29, the private purchaser is without notice of the HP agreement if he has no actual notice of the hire purchase agreement. The case authority is Barker against Bell. The seller in this case told the private purchaser that the seller had bought the car under hire purchase from X finance company, and he said he had paid off the final installments. S, the seller, showed the private purchaser a receipt from X finance company with a stamp that said final installment paid. But in fact, the seller had taken the car from Z finance company, and the seller had not paid off the installments. So the question for the court was whether the private purchaser had noticed that the car was still under finance. The court said the private purchaser was not aware of the relevant HP agreement. The relevant one was the HP agreement for Z finance company. The private purchaser was not shown the relevant HP agreement. So the private purchaser did get good title. He had no notice. Constructive notice, the court said, is not sufficient. It needs to be actual notice. As I said, with sections 27.3 and 27.4, if the first private purchaser is mala fides or has notice, no subsequent private purchaser gets good title. So no one else gets protection. Remember, NEM against Jones. If someone along the chain is a thief, even the private purchaser will not get good title. The burden of proof of good faith and no notice is on the private purchaser. The third condition, in order for the HP exception to apply, is that there must be a disposition to the private purchaser. Section 29 defines disposition as any sale or contract of sale. Now, the Hire Purchase Act does not define sale, so always we look to the Sale of Goods Act for help. We know what Section 2 of the Sale of Goods Act says. Section 2 says a contract of sale is a contract whereby the seller transfers or agrees to transfer property in goods to the buyer for money consideration. If disposition means sale, then money must be involved. If no money, no sale. If no money, no disposition. So the private purchaser must have paid money for the car. Otherwise, the Hire Purchase Act will not help. In VFS against JF Plant, the hirer owed private purchaser £45,000. The hirer gave the car to the private purchaser to discharge that debt. who is the owner? Original owner or the private purchaser? The court said the original owner, because the disposition to the private purchaser was not for money. So the HP Act did not help the private purchaser. Forbearance to sue was not sufficient. Now, just on a side note, actually, the private purchaser in VFS against JF Plant, the PP, the private purchaser, was a company, but that's okay. We said a company can be a private purchaser as long as it is not involved in a motor trade or involved with car finance. We also saw the case of Kulkarni against Manor Credit. We saw this before. We saw this under Section 18, Rule 5. The court said a brand new car without a number plate was not yet in a deliverable state. Kulkarni is also a Nemo Act case. Dr. Kulkarni ordered a new Mercedes from a dealer. Dr. Kulkarni paid the dealer in advance. The dealer was fraudulent. The dealer did not buy the Mercedes as he should have done, but he took the Mercedes on hire purchase from the finance company. The dealer went bust. Who is the owner? The finance company or Dr. Kulkarni? The Court of Appeal said Dr. Kulkarni got good title. Section 27, Nemo exception applied. By the way, let's go back to the House of Lords case of Shogun Finance against Hudson. This was the mistaken identity case. This was where the rogue pretended he was Mr. Patel. Shogun Finance let the rogue have possession of the car on finance. The rogue then sells the car to Mr. Hudson. The question for the court was who was the owner of the car? The finance company, Shogun Finance, or the innocent buyer, Mr. Hudson? Mr. Hudson argued that he was a private purchaser, so the Hire Purchase Act exception applied to help him. House of Lords said no. The private purchaser, Mr. Hudson, did not buy from the debtor. He bought it from a rogue who was pretending to be the debtor. So the Hire Purchase Act exception did not help Mr. Hudson. The finance company was still the owner. Now, those are the Nemodat exceptions. Let's look at the remedies for conversion. Let's look at the Torts Interference with Goods Act 1977. This act applies not only to the hire purchase exception. The 1977 Act applies to anyone who wrongfully interferes with the owner's goods. Everyone in the chain is liable in conversion to the original owner for wrongfully interfering with his goods. This is strict liability. It does not matter that the seller did not know the goods were someone else's goods. It does not matter the seller acted in good faith. Conversion is a purely civil wrong. It's not the same as theft. Sure, theft is an act inconsistent with another's rights. So yes, theft will be a conversion, but not all conversions are thefts, because conversion does not require dishonesty. Anyone along the chain can be sued. In practice, the true owner will try and get his goods back from the person in possession. If he can, great, no need to go to court. But if that person in possession refuses, the owner brings an action in conversion. The court will either order the person in possession to give the goods back or pay damages in lieu. How much damages? Well, damages is the value of the goods at the date of conversion. This is often the market price, but the court has a very wide discretion. Sometimes it's more, sometimes it's less. For instance, if the actual value of the goods is less than market value, the court has a discretion to award the lesser value. Or maybe the market price has shot up between the date of conversion and the trial, the court can always award more. Or maybe if the goods are modified, so the value has gone up, the court might allow for a certain amount to represent the value of the improvement. So the court has a very wide discretion. So if the owner incurs special loss as a direct consequence of conversion, the court can always allow special damages. So if it is a builder and you are deprived of tools because someone has sold it off, he can recover his loss of wages. Now, if a buyer cannot rely on the Nemo DAD exception, then he must return the goods to the owner or pay conversion damages. The buyer's claim is against his seller for breach of either Section 12 Sale of Goods Act title or Section 17 CRA title. Liability is then passed back up the chain. Note, if the Nemo DAD exception applies, the original owner then cannot sue the bona fide purchaser in conversion. The owner can just sue everyone else. Just a couple of words about the Limitation Act 1980. The general rule is there's a 6-year limitation period. Now, there are tons of exceptions, of course. If, for instance, a negligence claim, well, it's 6 years from the Negligent Act, but it's 3 years for personal injuries. For contract claims, 6 years from breach of contract, 12 years if by deed. Now, we know that a thief can never pass title. NEM against Jones made it very clear. It means the original owner can always sue everyone in the chain for conversion. One exception. It's a complex exception. But essentially, if goods are stolen and they are sold to a bona fide purchaser, the original owner is time barred from bringing a claim 6 years after the sale to the first bona fide purchaser. Have a look at the diagram on the screen. Time only starts to run when the thief sells to bona fide purchaser number 1. So let's say in this example, the thief steals a painting. It doesn't matter when he steals it, but if he sells it to the bona fide purchaser 1 in 2015, that's the time when the clock starts ticking. 6 years from 2015 ends 2021. So after 2021, the original owner's claim is time barred. If bona fide purchaser 1 sells to bona fide purchaser number 2 in 2022, absolutely fine. Bona fides means, of course, in good faith. Subjective, of course. Now, if bona fide purchaser 1 doesn't ask any questions, but he keeps the goods for 6 years locked up in a cupboard, we know the original owner cannot claim the goods back because it is time barred, but the burden of proof is on the bona fide purchaser to show he acted in good faith. It would be a very heavy burden if, say, he was an art dealer or he's a museum people. Now, those are the Nemo DAD exceptions. Every family should buy my very small house. Now, how do these Nemo DAD questions come up in the exams? Well, they can come up as very lovely essay questions. These sample questions are on page 31 of your handout. Now, I'll read them out loud just once, okay? So these are very typical essay questions on NemoDAT. Let's just read it out loud. It's on page 31 of your handout. In principle, the protection of the innocent buyer is a more sensible and more realistic approach. If the owner of goods voluntarily parts with possession of them, he takes upon himself certain risks. He can make his own judgment as to the creditworthiness of the party to whom he gives possession. And if his trust turns out to be ill-founded, he ought not to put the consequences of his own mistaken judgment onto the shoulders of a blameless third party. Critically consider the extent to which the NemoDAT rules consistently protect the rights of the bona fide purchaser of goods. The relevant question in this sort of case is, which of two innocent parties shall suffer for the fraud of a third? The plain answer is that the loss should be divided between them in such proportion as is just in all the circumstances. If it be pure misfortune, the loss should be borne equally. If the fault or imprudence of either party has caused or contributed to the loss, it should be borne by that party in the whole or in the greater part. Assess the extent to which the current NemoDAT rules adequately protect the interest of parties. Now, they're all, if you get a NemoDAT essay questions, they are all about the same. I'm going to spend just 5 minutes, 10 minutes, just doing a very brief outline of the essay answer for you, because essay questions are virtually all the same. Invariably, you are asked to discuss the criticisms of the NemoDAT law. Start off by pointing out that the common law always favored an owner's property rights. In other words, the owner is always the owner. That is the NemoDAT rule. That's why if you're not the owner, you can't pass ownership. This is now embodied in section 21 sub 1 of the Sale of Goods Act. But this is not always fair because the innocent buyer suffers loss. If an owner voluntarily parts with possession of the goods, surely he should take the risk that something might happen to the goods, as opposed to a totally innocent buyer having to suffer the loss. The law needs to consider the interests of the innocent buyer. Surely the owner is in a better position to assess the creditworthiness of the person he gives possession of his goods to. If the person the owner gives possession to turns out to be a rogue, the owner should bear the risk that the person is a rogue. Why should the innocent third party be the one to suffer the loss? For sure, the exceptions are inconsistent. We can take, for instance, 2 examples. Delivery. Under section 24, second sale by seller in possession, and section 25, buyer in possession exceptions, the bona fide third party must take delivery before these exceptions help him. Whereas the other exceptions, estoppel, factors, 23, voidable title, there's no mention of delivery. There's no need for third party to take delivery before the exceptions help him. What's the point of the difference? Why should there be a need to take delivery anyway? The better solution is that there should be no requirement for the third party to take delivery. It is difficult to see why the presence or absence of delivery should make any difference to the relationship between the original owner and the innocent third party. Why should anyone care whether the innocent third party takes possession? What matters surely is reliance by the innocent third party. Reliance can be evidenced, for instance, by paying money. Delivery is just beside the point. Another example to illustrate how inconsistent the Nemo Dat exceptions are is that the Nemo Dat rules exclude the rights of an innocent third party if he was a gratuitous transferee. In other words, he must always have been a bona fide purchaser for value. For value means he must have paid something of value for the goods. He can never be protected if he is an innocent receiver of goods. So, strictly speaking, actually, sections 24 and 25 and the factors exception, they don't say anything about the third party needing to give value. But the courts have consistently required that the third party must be a bona fide purchaser for value. He must have given something of value in exchange for the goods. But point is, why is it not possible to say that an owner entrusting goods to a person who turns out to be a rogue took the risk of unauthorized gifts to a third party, as well as a sale to a third party for value? I mean, the Nemo Dat rules are haphazard. There is no real consistency. But we need to have a pragmatic balance. We need to have a practical solution. As you know, Devlin in Ingram against Little said, where there are two innocent parties, one had to suffer the loss. He said, if there's no good basis for choosing between the two, then we need to come up with a system so the loss can be apportioned. He said this was fair. But remember, the Law Reform Committee considered this, ultimately rejected the notion of apportionment on the basis that it was impractical. So how does the law deal with the problem if apportionment is not workable? We cannot have two people owning the same goods. One is going to lose out. That's why Denning was saying there's a struggle between these two competing principles. Because it is not practical to apportion loss, the existing rules place the loss on one or the other, either the owner or the bona fide purchaser. But the rules are not consistent, and sometimes they are difficult to justify, and the exceptions are very narrow. Unless the buyer can bring himself within quite technical rules, the innocent buyer loses out. Nemo Dat exceptions exist to help the innocent third party, but do they really protect the third party? Denning in Bishopsgate says, two principles have striven from mastery. Goff says, no, fundamental principle is Nemo Dat. There are exceptions, but what he said was the exceptions are very minor. So there are opposing views. At the end of the day, it is quite difficult for the third party to fall within the exceptions. On the whole, the courts seem to protect the original owner. The upshot is that the Nemo Dat exceptions is one big mess. And there has only been one reform in the last 50 years, and that is to abolish the market ouvert exception. And do you know why the market ouvert rule was abolished? I'll tell you. It's because in 1990, two paintings were stolen from Lincoln's Inn, a Gainsborough and a Reynolds. They were worth £2 million. 3 years later, a chap turned up at Sotheby's, the auctioneers, and he asked to have the two paintings valued. Sotheby's immediately recognized them as the stolen paintings. The chap was arrested. The chap was an amateur art collector. He bought the paintings in Bermondsey Market for £145. He was not an art expert, he just liked them. Under the market ouvert exception, the chap got good title. Everyone was outraged. So that's why Parliament bowed to pressure and they abolished the market ouvert exception. So you see, although the market ouvert exception has been abolished, if you're going to do an essay question on Nemo Dat, it's a good idea to show that you are aware that it's been abolished. But the reason why you mention it is to make the point that it is the only amendment in the past 50 years, despite numerous criticisms of the Nemo Dat rule, which, as we've discussed, are haphazard and inconsistent. So conclude your essay saying, despite the consistent criticisms, the abolition of the market ouvert rule has been the only reform. Nemo Dat questions come up as very nice essays. Maybe you will get one for your exam. Maybe we will set an essay question. But they also come up as problem questions. Now, before we look at the sample problem question, let me tell you about feeding of title. So the question is, could inconsistency within one exception be discussed for question 1? Contracts, well, you can do, because that depends on whether the contract is void or voidable. So that's why, you see, section 23 can only help you if your contract is voidable. It cannot help you, section 23 cannot help you when your contract is void. So yes, legitimately, you can bring about and talk about a contract in absentis or praesentis. But in exam situations, if it is an essay question, you will be better off giving 4 examples rather than concentrate on just one. Because if you're going to discuss contracts into praesentis and into absentis, that's going to take you too long. Too long means you'll only end up talking about one exception. Really, you should talk about 4, maybe even 5, but 3, 4, 5, minimum 3. 4 is better. If you only end up talking about section 23 and you go into the detail about praesentis and absentis, I think that's going to take you too long. Remember, you have 1 hour to answer each question, all right? You can write as much as you like, but you've only got 1 hour. So time is going to restrict what you can say. So better to use 4 examples using a big long paragraph on each rather than concentrating on just one exception, okay? All right, let's, before we look at a problem question, which I want to, let's talk about, first of all, of feeding of title. Let's look at feeding of title. Now, the first case to start off with is Butterworth against Kingsway Motors. Let me tell you about this case. The hirer wrongfully sold a car to X, to Y, to Kingsway Motors, who then sold it to Butterworth. Butterworth had possession of the car for 11 months. Then he found out he was not officially the owner. So he then wrote to Kingsway Motors asking for his money back. Breach of Section 12, Sale of Goods Act. This was well before the CRA. 1 week later, the hirer paid his final installments. The court said, when the hirer made the final payment and exercised her option to purchase, her title fed down the line. The process of feeding stopped at Kingsway Motors, who became the owner of the car. Now, ownership did not pass to Butterworth because he had rejected the car 1 week earlier. So Butterworth got all his money back on grounds of total failure of consideration. Now, in court in this case, one of the lawyers asked what the position would be if Butterworth did not know any of this. In other words, he did not reject when he did reject. If title had fed to him, can Butterworth still reject? Well, Pearson, the judge in Butterworth, he felt some difficulty on this point. He didn't quite answer that question. In Australia, the courts have said it would be too late to rescind. The facts of the Australian case, Patton against Thomas Motors, were the same as in Butterworth against Kingsway Motors, except Kingsway Motors was Thomas Motors and Butterworth was Patten, but the facts were the same. The hirer paid all the instalments and exercised the option to purchase before Patten sued. The court in New South Wales had said, title fed through. Patten cannot reject. Of course, Butterworth against Kingsway Motors was a 1954 case, so it was decided before the HP Act 1964. Otherwise, the HP exception would apply. But even if it did apply, it seems that a buyer has a choice whether to reject or not. Warman against Southern Counties. No need for the facts, but go on to say that this point was confirmed in Barber against NWS Bank. It's the usual facts. The hirer wrongfully sold the car to X, to Y, etc., etc., finally to NWS Bank, who then conditionally sold it to Barber. The agreement between NWS Bank and Barber had an ROT clause. Now, ROT clauses, as we will learn, are always express terms of the contract. It always needs to be expressly incorporated. The ROT clause said that property remained with NWS Bank until full payment. 20 months later, Barber found out that NWS Bank was not the owner. NWS Bank was innocent. They didn't know the car was still under previous financing. Barber sued for his money back. The Court of Appeal was unanimous. They said, yes, Barber was entitled to a full refund. The court said ROT clause was an express term, that NWS Bank was the owner of a car where they contracted with Barber. The express term was a condition. There was a breach of this condition, so Barber was entitled to rescind. Although the HP Act exception applied, in other words, the private purchaser got good title. Section 27 sub 6, we mentioned this, made it clear that it did not excuse a trade purchaser or finance company like NWS Bank from civil or criminal liability. So Barber can plead breach of the express condition as to title. So you see, it seems that even if a buyer gets title under the Nemo DAD exception and the buyer has lost nothing, the buyer can still reject. But I wonder why Barber didn't argue breach of Section 12. After all, this was a conditional sale contract, so we know the Sale of Goods Act applies, Lee against Butler. Section 12 says there is an implied condition the seller had the right to sell. So why didn't Barber simply argue breach of Section 12? The answer is because Barber couldn't. Barber couldn't because Section 12 says it is an implied condition that the seller had the right to sell at the time that property is to pass. In other words, only once Barber has paid all the installments. But Barber hadn't paid up all his installments. He was 20 months into the contract, but it was not yet the end of the conditional sale period, which is why Barber had to rely on breach of the ROT express term in the contract. And the court said this express term was a condition. The breach was a breach of a condition entitling the buyer to rescind the contract. You see, we will look at the detail of Section 12 later, but Section 12 does not say the seller undertakes the buyer will get good title. If you get title, great. All Section 12 says is that the seller must have the right to sell at the time that property is to pass. So the seller, you see, can be in breach of Section 12, even if the buyer got good title, because, for instance, one of the Nemo DAD exceptions apply. In Barber, buyer did get good title under the HP Act. Nevertheless, the Court of Appeal said that the buyer can still rescind the transaction on Rowland against Duval grounds. In other words, on total failure of consideration, even after 20 months. So having the right to sell and you getting title are two very different things. We'll discuss Section 12 in more detail later. Let's look at a sample problem question. This is on page 33 of your handout. Page 33 of your handout. It's probably easier for you to read it from your handout. So what I will do now is I will read the question out loud once, give you a minute to reread, and then we'll answer it. Okay? I'll read it with you out loud once, give you a minute to reread. Lucy took a car on hire purchase terms from Performance Finance Limited. Lucy could not afford the monthly payments, and with 5 installments still to pay, Lucy sold it to Remy, a motor dealer, for £14,000. Remy then sold the car to Aileen, a driving instructor, for £16,000. Aileen took the car to Bob, a local garage owner, to be repaired. A few days later, Bob telephoned Aileen to say that he had received an offer of £17,000 for the car. This was completely untrue. Aileen said that she would be willing to sell the car for £17,000 and asked Bob to do so if this was possible. Bob sold the car together with a forged registration document which he had obtained to Patsy for £14,000. Patsy then sold the car to Jarvis for £15,000. Patsy accepted a cheque from Jarvis for the purchase price. The cheque was dishonoured, and so, unable to contact Jarvis, Patsy immediately contacted the police. Jarvis then sold the car to Matthew for £15,500. Advise Matthew. All right, let me give you 1 minute just to reread it, to make sure you've got the facts straight in your head. All right, give you 1 minute to reread. Okay, we're here to advise Matthew. Now, what does Matthew want to know, our client? Well, he wants to know if he owns the car that he bought. The general rule always start off is Nemo Dat quod non habet. Only the owner or his authorized agent can pass good title. Now, if Matthew does not get good title, his seller is clearly in breach of section 12 or section 17. Now, we need to consider each disposition in turn. We'll worry about whether his contract with Jarvis is B2B or B2C later. For now, it doesn't matter. The Nemo DAD exceptions are the same, whether it's B2B or B2C. If the Nemo DAD exceptions apply so that our client Matthew gets good title, then he doesn't need to sue his seller. So we may not need to know if Matthew's contract with Jarvis is B2B or B2C. Let's do the rough work. What you need to do is to be very clear the sequence of events. Who sold to who first? Who sold to who next? It should look something like this. Now, once you've got this basic structure, you go through each bit to decide what the main issue is. Now, I've broken it down to 3 lines, but that's only because I can't fit everything into one line. What is important is it sets out the sequence of events. We're just going to do rough work for now. The first thing that happens is between Performance Finance and Lucy. What do we need to say? What do we need to say? Well, the first thing to say is we assume that Performance Finance are the owners. Now, there is nothing to suggest anything otherwise. So, okay, Lucy takes the car on hire purchase. So is Lucy now the owner? Well, remember, we're looking at the Nemo DAD rule. You can't give what you haven't got. And the opposite of that is if you have got it, you can give it. So we're just saying that Performance Finance is the owner of the car, so they can give ownership to Lucy. So does Lucy have title? Well, no, because she has taken it on hire purchase. So Lucy does not have title. She does not have the right to sell, but we are told she does sell it to Remy. Nemo DAD can't give what you haven't got. But do any of the exceptions apply to help Remy? Which one jumps up? Which one jumps up? You tell me. I know we've only just done it, but which exceptions might help Remy? Lucy doesn't have the right to sell. She's just the hirer, but she's just sold it to Remy. You tell me, which of the exceptions might help? You're right. I think the Hire Purchase Act exception is definitely worth discussing. But you and I already know that ultimately, although we discuss the HP exception, the HP exception won't help Remy. Why not? You tell me. Why is the HP exception not going to help Remy? Why not? You tell me. That's correct. Thank you very much. That's because Remy is not a private purchaser. Remy is a trade or finance person, and the HP exception won't help any trade or finance person in the chain. Okay, so here, Remy does not get title. Well, what about Ailey? What about Ailey? What exception might help Ailey? What do you think? What HB exception might help Ailey? Well, I think this time HB Act exception might apply. So I think it is possible for Ailey to get title. So actually, this first bit, this first line is all about the HP exception. I can't write HP. Anyway, look, there you go. Right, so this first line is all about the HP exception. So we know the detail on that. We can discuss this in full, but we are only doing rough work for now. All right, so what happens now is Aileen leaves the car with Bob for repair. And Bob pretends that someone is interested to buy the car. Aileen agrees to sell it for £17,000. What does Bob do? Bob sells it for less. Now, Bob did not have title, did he? And he did not have the authority to sell for less than £17,000. So Nemo Dat is the general rule. But which Nemo Dat exception might apply to pass title to Patsy? Go through the sentence. Every family should buy my very small house. Delete the ones which are irrelevant. And to be frank, it can't be the HP exception, can it? Because we've already discussed the HP exception in the first part. And I can tell you now that we are not going to give you the same thing twice. You can put your money on that. Now, normally I would write down all the exceptions here. So I would go down every family should buy my very small house, and I will delete it. So I'll write on the side of my rough work and I will delete it. So we know it's not going to be HP. We know that because the first part's on HP. It's definitely not stolen goods, nothing to do with stolen goods. What about voidable title? Section 23. Does it involve a rogue who gives Eileen a check which bounces? No, that's because Jarvis is the rogue. This guy down here, he's the rogue. That's the third part. Jarvis is the rogue who gives Patsy a check. So we definitely need to discuss section 23 down here for sure. So this bit between Aileen and Bob and Patsy can't be about voidable title. It's certainly not market au vert because that exception has been abolished. You'd only ever mention market au vert if there's an essay question on Nemo Dat. You will never bring it in when it's a problem question. But what about the buyer in possession exception, section 25? What about the buyer in possession exception, section 25? Will that help Patsy? Is Bob a buyer in possession? Is that worth mentioning? Is Bob a buyer in possession? Because if he's a buyer in possession, maybe Patsy gets good title under section 25 exception. The answer is no, because Bob is not a buyer in possession. Bob has not agreed to buy the car from Aileen, so the buyer in possession exception cannot apply. I'm just doing things by process of elimination. What about section 24, second sale by seller in possession? Nope, that doesn't apply. It doesn't apply because it's not a situation when a seller has sold to buyer number one and then he sells the same thing to buyer number two. It's not that situation at all. Ah, yes. What about the factors exception? Thank you. I agree. This is definitely relevant because Bob is a mercantile agent, right? Because like I said, every time the question involves someone who is a car dealer, an auctioneer, an art dealer, these people are invariably mercantile agents. So it is this factors exception which we need to discuss. So we know, as far as the factors exception is concerned, there are 4 conditions we need to discuss that need to be dissatisfied. But of course, that's what we will need to go through in the full answer. For now, I'm just doing rough work. What about the estoppel exception? Is that relevant? Do we need to discuss it? Well, I would say yes, because Aileen gives possession of her car to Bob. We know that giving someone possession of your goods is not itself sufficient to say that you made an intentional or negligent representation, that someone else is the owner or someone else has the right to sell. But I think it is worth talking about, and we need to mention it. I don't think it applies to help Patsy, but then we already know that the factors exception is probably the one that helps. What about the last bit? Patsy sells to Jarvis. Jarvis sells to our client Matthew. Well, we already mentioned this. We said every time a check bounces, it's bound to be a discussion on Section 23 voidable title exception, especially when the question says Patsy called the police. That is clearly giving you a clue that you need to discuss Car and Universal Finance against Caldwell. Because in Car and Universal Finance, the owner called the AA and the police. So the facts are similar to this question we're looking at. And every time Car and Universal Finance comes up, you need to query whether you need to go into Section 25 buyer in possession exception. That's because Car and Universal Finance is so severely criticized that Newtons of Wembley against Williams said, even if the owner called the AA and police and avoids title under Section 23, Section 25 might operate anyway, so that title passes to the bona fide purchaser. That is certainly the situation where Jarvis, the rogue, has voidable title. Remember, Section 23 does not apply to a rogue with a void title, and the contract is void for unilateral mistake where one party makes a mistake about the identity of the other party. We know there are two types of cases. Did Patsy contract with Jarvis face to face? If the answer is yes, then this is a contract enterprise sentence. If she did not meet Jarvis and they concluded the contract not face to face, then this might be a contract inter absentis. Now, the rules are very different, completely different. But actually, we're not given enough information, are we? Did Patsy contract absentis or prisentis? I think we need to query this. You tell me, what would our client Matthew prefer? Absentis or prisentis? What would our client Matthew prefer? Would our client prefer the contract between Patsy and Jarvis to be absentis or prisentis? Thank you very much. Excellent. The answer is correct. Thank you. Face to face, prisentis. Because if the contract between Patsy and Jarvis is absentis and the mistaken identity amounts to an operative mistake, then the contract between Patsy and Jarvis is void ab initio. So anyone with a void title can never, ever pass good title, because someone with void title means there was no contract in the first place. So if that's the case, our client is going to lose out. That's why we would rather have the contract between Patsy and Jarvis be an inter-prisentis case. So it's rather important, isn't it, to know whether Jarvis's title is voidable or void. We don't know for sure. So what are you going to do? Are you going to answer the question as if the contract between Patsy and Jarvis is absentis, or are you going to answer the question as if it was a prisentis contract? What are you going to do in the exam? You're not sure whether it's absentis or prisentis. What are you going to do? Fantastic. That's exactly the right attitude. The answer is we do both. We cover the alternative. Very good. Now, once you've discussed all of this, you then need to conclude, of course, because if our client Matthew gets title, bang, this is the answer. If Matthew does not get title, bang, that is the answer. Just one more thing I think we need to discuss. We're told Lucy only has 5 installments outstanding. Why are you told this? Why are we told Lucy only has 5 installments outstanding? What's the possible significance of that? What's the possible significance? Well, the answer is, I wonder, thank you, yes, very good, excellent, feeding of title. I wonder if Lucy, by any chance, carried on paying her last installments. Because if she did she exercise her option to purchase? Because if the answer is yes, maybe we ought to mention feeding of title. Anyway, I think the neat version of the rough work should look something like that. We're going to end our lecture here, and tomorrow when we come back, we will do this answer in full. This is merely the rough work, and we're going to be starting off with this diagram, all right? So we will do the answer in full tomorrow. That's what we're going to start off with. All right, we'll end the lecture now. See you tomorrow.